Hello viewers, Attorney Buado here. Welcome to the Criminal Law Jurist. This is episode 11, part 1. Article 4. Who shall incur criminal liability? Article 4 identifies who incurs criminal liability. First, any person committing a felony, although the wrongful act done be different from that which he intended. Second, any person who commits an impossible crime. Let us deal first with impossible crime. This crime is only in the Philippines. What is an impossible crime? According to Article 4, Paragraph 2, it is an act which would be an offense against persons or property were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. What are the requisites of an impossible crime? The act performed would be an offense against persons or property. Second, the act was done with evil intent. And third, its accomplishment was inherently impossible, or the means employed was either inadequate or ineffectual. The first element requires that the crime should be an offense against persons or property. What are the crimes against persons? These are parricide, murder, homicide, abortion, infanticide, physical injuries, and rape. What are the crimes against property? These are robbery, theft, estafa, arson, and malicious mischief. Only these crimes can be the subject of impossible crime. All others like threat, coercion, rebellion cannot be. The second element is that the offender must have evil intent. In the previous episode, we said that intent is shown by the means used to bring about his desired result. Being a mental process which cannot be seen, intent is shown by the means used by the offender. So intent is difficult to prove, hence there is a need for presumption by the mere commission of an illegal act. Example, the act of stabbing a person shows that the offender has intent to kill. The third element refers to the reason why the crime was impossible of accomplishment. There are three causes of impossibility. First, the crime is inherently impossible of accomplishment. Second, the means employed was inadequate. And third, the means employed was ineffectual. There are two kinds of inherent impossibility. First is legal impossibility, and the other is factual impossibility. Examples. Legal impossibility means that even if the intended act was completed, it would not amount to a crime, like killing a dead person. Example, Juan stabbed Pedro, who appeared to be sleeping, but was actually dead already because of heart attack. That is legal impossibility because even if he did everything to kill Pedro, he cannot kill him because he is already dead. Factual impossibility occurs when something extraneous prevented the commission of the crime. The crime would not be accomplished because there is a final act that cannot be done, such as the akyat bahay gang opening a safe that turns out to be empty. The crime of robbery cannot be completed because there is nothing to steal. Which brings us to the question, should the offender know that his crime is impossible of accomplishment? No, the offender must not know that, because why would he go to all the trouble and danger of invading a home if he knew that there is nothing to steal? Why would he pick a pocket without a wallet? Or why would he risk being caught of killing another when that other is already dead? Another question, is impossible crime a crime? Objectively, there is no crime committed. But subjectively, there is a criminal tendency that is what is being punished to prevent a person from becoming a criminal, to quell the tendency to commit a crime. Last question, is there an impossible crime of rape? Before the effectivity of RA 8353, the anti-rape law of 1997, there is none. Because then, rape is a crime against chastity. When RA 8353 took effect, there is now an impossible crime of rape because it is now a crime against person. In the next episode, we will continue this article. We will talk about paragraph 1 of Article 4.